all tangentially related. Today was Tesla's Edison's Medicine, dealing with the controversy between Edison and Tesla over intellectual property rights. Lost of lives. It's not just our penchant for hairbending in this class. I think you guys have noticed we have a number of different songs we play. As all of you know, today we have our IP panel. We have our distinguished guests here. Mr. King had to cancel at the last minute due to a sudden deposition. He has to be with us tomorrow. And Mr. Tyson will not be here until the second half of the class. But let me go ahead and introduce, starting with the far end left, Mr. Nathan Calvert. Mr. Nathan Calvert Esquire is a member of the Torkelson Law Group. He previously worked with Bishop Richardson, focuses on prosecution, licensing, and patent litigation. Nathan holds a BS in engineering and a JD from the University of Texas. He has conducted numerous patent litigations. He's personally one of the first people on my speed dial whenever I had a immediate patent question. He also worked for 4 years as an operations specialist at the Central Intelligence Agency. So he's one of those guys you really want to pay attention to because he can be somewhat sly in certain concepts. Next, we have Mr. Gavin Augustus Renfro, Esquire, affectionately known by most as Austin Renfro. Austin, in addition to being one of the first of counsels for Roberts & Roberts, previously worked at Howard LLP in Houston, is currently the Vice President in charge of IT management at GA Renfro, and the corporate counsel for GA Renfro, one of the largest insurance companies in the U.S. He's a native of Birmingham, Alabama, and travels all over the world, particularly as a delegate to the IP High Court of Japan. He specializes in patent and trademark prosecution and is one of Justin and my personal favorite people to travel internationally. He can tell you a lot of stories, hopefully not them today. And finally, we also have Mr. Louis Baum Esquire. Mr. Baum has more accolades than I can mention in this entire 3-hour class. Also has more experience teaching than I think all the rest of the four of us put together. Mr. Baum is one of the world's experts on architectural copyright, and personally, one of the very good people on the planet I consider a complete utter badass when it comes to intellectual property. I cannot say these accolades enough. And on that note, gentlemen, I'm going to let you take it away.
Sure, yeah. So we've done this for a few years now, where we, how we organized it is we would do just kind of a general overview of intellectual property, what it is and how it works, and then go through it topic by topic. So I think what we plan on today is to start out with trademark and then go through copyright and finally end with patent and trade secret type of issues because they tend to generate most of the discussion. So from what I understand, you guys are fairly new to the concepts of intellectual property in general, right? Is that correct? Do you guys, like, who knows all of how many fields there are in intellectual property? What types are there? There's generally 4 or 5 kinds of IP. Who can name them all? So not a lot of hands. Yeah, so we got basically trademark, copyright, patent, and then trade secret. And then there's a few other kind of fringe types of IP that get shoehorned in various areas, and we'll talk about those too. So generally, let me just introduce the basics, and then I'm going to launch right into trademark, and you guys just feel free to jump in whenever you want to. And my voice is getting kind of rough today, so I'm going to hold on to the mic, but I'll just pass it down when we have comments. So I like to start with trademark because every business has a trademark. You know, and most businesses will have some copyright. It's very rare that a non-tech business has patent issues. And then a lot of businesses have trade secrets. But by far the most common type of IP that anyone in business needs to know is trademark and what it is. So trademark is used to identify a brand name or the name of your business. And you register the trademark and then you stop others from using that name in a way that can be confused with your business. That's the basics of it. And so every business will have at least one trademark, usually to their business name. And if they sell product lines or services, that they have a name that goes with that product line, they'll trademark that, and they make trademark other little slogans that go with it, all kinds of things. So it's a short phrase or a symbol or a combination of words that identifies a product or business. So that's why they call it a mark. It identifies your business or your product in the market. Yeah, so trade dress goes along with that, and it's a combination of colors, look and feel, and all that kind of thing. Say the pink decor of a Taco Cabana, and all the various shapes that go with that. That's considered trade dress. They have a lawsuit about that. So that goes along with trademark, and you can use it in the same way. Their trade dress at Taco Cabana identifies that it's a Taco Cabana. So then we'll go back to trademark, we'll just move on to copyright. Copyright is works of authorship and artistic types of things. So paintings, novels, computer source code, website graphics, all that kind of thing. So almost every business will have copyright issues. And almost every business creates copyright. Copyright is not registered, you get it automatically, so we'll go through that in more detail later. So it's probably the second most common kind of IP. So the next most common is a trade secret. A trade secret is just a secret that you keep in your business, and because you keep it confidential, you don't disclose it and you protect it, then if someone steals that and copies it or starts using it to compete with you, you can sue them for misappropriating your trade secret. So the most common trade secret by far is your customer list. Your internal business processes, internal technology processes, all those kinds of things constitute a trade secret. So generally that's a trade secret. And then the most controversial is patents, but most businesses don't have patents. So tech companies mostly have patents. Not a lot of other kinds of businesses actually go after patents. Business method patents are a new thing, and they're used a lot now, but they're used generally in businesses that are taking their business online or taking their business mobile and somehow want to integrate technology into a traditional bricks and mortar business. But generally, patents are made by tech companies or enforced by tech companies and all that. So a patent just covers an invention, and what that legally is hard to define, but it's basically products or processes that are unique in some way. And so if you're the first one to create this product or process, then you can apply for a patent, and it's granted by the federal government, and then you can sue someone with that patent and keep them from competing with you in your space and license that patent to others. So that's generally the overview of intellectual property. There's a few other niche topics I think we'll get into later, but anybody have anything to add to that before we just go right into trademarks? And any questions on that in general? Is it clear to everybody? Is anything I said not clear?
So the way I generally like to think about intellectual property is who it benefits, why it was created. The reason why trademarks were created were actually not to protect as much the owner of the trademark as much as to protect the public. And the reason why is because you don't want to go, for instance, buy a Coca-Cola and it turned out to be some totally different company that's selling something that you weren't expecting them to sell. And so, the creation of a trademark actually happens, as soon as you start using this thing that identifies you uniquely, and invest at that moment. Now you can go and you can apply for federal registration for trademark, which protects it across the country, and we can go into that some more. But really, that's the point of the trademark, is to really protect the public. Copyrights also vest upon creation of a unique, artistic, Yeah, I'm sorry, I know. As a patent guy, everything's unique or not unique to me, but you're right. Yeah, we'll get to that in a minute. But something artistic, something that you would think that an artist would create, something like that. And so copyrights are really there to protect the person who's coming up with something beautiful and that's the point of that. Patents are actually also kind of a public protection, but they're both a public protection as well as a protection for the inventor. And I'll stop blabbing in a minute. We'll get to patents at the end. But the point of a patent is you want to actually give the public a reason, give the inventors out there a reason to create something original, create something novel, create something that actually does good for the public. And in return for that, you're going to give them protection over that, which makes them want to do it. But at the end, and we'll talk about that in a little while too, that person is required to give that invention away to the public to benefit the public. So that's kind of a way to think about all that. And then trade secret is really just, you don't want somebody to steal your customer list, you don't want somebody to steal your ingredients for how to make Coca-Cola, and so that's a protection really for businesses. It's a soft protection that's covered a lot by state law, to protect those things for companies. So that's just kind of another way to think about it.
Make a couple of introductory comments. When we were talking about what, as entrepreneurs or as business people, how this affects you, it's easy to focus on, okay, my business might have patents, or maybe it's not a tech company, so it's not going to have patents, or, okay, we have a trade name, or, well, do we really create things? Do we have copyrights? That's one way to look at it, but you also have to look at it from the flip side, and that is, I don't care what your business is, you're going to be using somebody else's work that's going to get covered by patents, trademarks, copyrights. And remember that, especially for copyrights and patents, what the government has done is given the patent holder, the copyright holder, a legal monopoly. If you have a copyright, you have a federally granted legal monopoly. You get to exclude everyone else for using or making copies or making derivatives of your work. If you own a patent, you have the right under federal law to exclude others from making, using, or selling your invention. Yes, right, wrong, or indifferent, that's what it is. So regardless of whether or not your business, has an IP portfolio, some do, some have, that's their whole business is to have an IP portfolio. Even if you're not on that side, you still need to understand this. Because especially if you're dealing in tech areas or, as you mentioned, I do a lot of work in the architectural field. And every architect out there has to deal with this on a daily basis. Because if you're using somebody else's work, there are rights that are being implicated. And whether or not you're over the line or not is something that affects you every day. And, as we have time to get into the remedies, especially in copyright law, the remedies are like the rabbit and Monty Python, the Holy Grail. They have big, mean, nasty, pointy teeth. And it can be a, complete, company-killing lawsuit if you fall into the wrong way on it. Now, if you're on the trigger end of it, rock and roll works out great. Anyway, there's a lot to cover here today, and I think, all of us, we want to take this conversation in the direction where you've got interest and you've got curiosity or you've got issues. I mean, everybody has issues. So just kind of let us know where you want to go with it.
Sure, you got to talk about trademarks. So Henning used to do trademarks, and he presented kind of the history of the marks and how they evolved throughout European common law. I don't know all the history, so somebody here knows that. Let's launch into that. That's always fun.
So, all right. So the history of trademarks, it's funny. Trademarks and patents are both some of the oldest forms of intellectual property protection in existence. Trademarks are kind of cool, and I don't have a PowerPoint presentation I usually get in front of me, but creation of trademarks actually began with blacksmiths long time ago who needed to identify their wares. Because you go off and a sword was one of the more expensive things that you would purchase back in the day, and you need to know it came from this really good blacksmith, not this really bad blacksmith down the road. And so, how are you going to identify this sword versus this sword? And it turns out that the way they did it was by actually stamping a mark, a seal or a crest into the products that they created, which couldn't easily be replicated back in the day before we had, machinery and automation. And that would be the identifying mark for, for that blacksmith, for that group. And so that's how you know, okay, this came from this person, this didn't come from this person. And so they've actually found, I want to say it was like 400 or 500-year-old swords that have got the mark, y'all remember that? Yeah, it was like Ludova. There was actually one from Ukraine too that they found but it actually shows the mark of the blacksmith, actually says, like, this is my sword, you know, whatever. And so that's how trademarks were actually created, is way back then. And of course, we've now enshrined that in a more formal law, you know, now. So there's the history of trademarks.
So where are we today with trademarks? Well, there's state law and there's federal law that will protect the trademarks that you create in your business. So generally that law protects a word, phrase, or symbol, or a combination thereof, that's used to identify the source of goods in commerce. And there's some exceptions to that, like trade dress, and it's a word, phrase, symbol, or combination. So in trade dress, it's a combination of things that identify the source of goods in commerce. But generally, that's where the trademark law has evolved. So in the past, the trademarks were granted by kings to monopolies to use certain words, but now they're granted by the state law and the federal law. Now, as you mentioned, you don't have to actually register your trademark when you first start using it. You have rights from the very first day you use that mark in commerce. So that's something that a lot of small businesses don't realize. They don't actually have to pay a lot if they're just starting their business right there locally in town. You don't have to go register your mark yet. Now, there are reasons why you should register it as soon as you can afford it. But as soon as you start using that mark in commerce, you get your trademark state rights to that mark throughout the territory that you're using it in. So keep that in mind as we talk about a lot of the concept of registration. And sure, as we talk about registration and applying for your marks and the process of getting a mark, well, a lot of your rights vest the very first day you start to use it. And this is true about copyrights too. Copyrights vest the first day you create your work of authorship.
I was going to add, when you're saying you have the rights from the time you start using it in commerce, generally true with one important caveat, as long as somebody hasn't beaten you to the punch. Because if someone is using that mark in the same geographic area, or if they've got a federal registration that covers all the U.S., then you don't have nothing. And so, again, in the past, one of the things, when I started practicing law, you always, you told clients to go out and have trademark search done before you get your paper stock ordered or whatever else. Now Google is your friend. And by doing a little bit of online research, it's amazing you can find out very quickly whether or not only does someone have a registered mark, but is someone else using, that particular phrase, in the space. And this is another whole topic about, just because someone's using, for example, Lexus. Everyone knows the car company. Well, there also is a legal database, Lexis, L-E-X-I-S. And when the Lexus, L-E-X-U-S brand came online in, the late 80s, Mead Data, who owned the Lexus name, sued and said, hey, wait a minute, that is potentially confusing to the consumer. And the courts threw it out because they said, wait a minute, you're in the legal database business, they're in the luxury car business. No consumer is likely to be confused that this car has something to do with the legal database. Get out of here. But, again, remember, of course, it's who's there first. It's like the first person to have been there and put their stake in the ground and says, this is mine. Now, how far out their boundaries go becomes a question of use, or if you register with the feds, then you can do what you want. But in general, you don't have it self-effectuated. If you're the first one and you start using it, then you've got a trademark. And then the question just becomes is how far out does it extend, both geographically as well as how broad the space is that you're using it.
I've actually got story time. I've actually got a story on this. So, trademark law is, I say this as a patent guy, it's to me, it's not a very clear-cut law. And the law itself is clear-cut, but just what you expect to happen when you file for a trademark, and you never know. And so, as a story, there's somebody that I've told the Roberts brothers about before. He's a good friend of mine. His name is Jake Joseph, and he actually went to college here. He started a clothing line He actually just finished a Kickstarter. Y'all can go look him up on the internet. And he's just a guy. He's just a guy like any of us, and he wanted to put his name on his clothes. And so he said, hey, I got introduced to him through a friend, and I do some pro bono IP work just, for fun. And he's like, hey, I need to register a trademark on my name because I want to put it on my clothes. I want to make sure it's protected. And I said, oh, okay, no problem. And so, we go to the USPTO website, we go look up the trademark, and we see nobody using Jake Joseph. Maybe there's another company that's using Jake something else. Maybe there's another company that's using something Joseph, but nobody's using Jake Joseph. So, you never know what happens, but somebody's gonna get mad at you. But okay, it looks like we're fine. Trademark registration, less than $200, takes about an hour to do it. Any of you guys could probably do it yourselves. Let's go do it. Well, unfortunately, two giant multinational conglomerate companies, both of who did clothing, one of them was named something Joseph, one of them was named Jake something, didn't really like that. And so they filed what's called a trademark opposition to his trademark registration. What that basically means is another company's come in and is telling the USPTO they should not get this trademark for all of these reasons. And again, remember that the point of a trademark is really to protect the public, and so they're claiming what's called likelihood of confusion. So, his name is Jake Joseph, and he makes, he's got his clothing line. Neither one of them does, the same kind of thing. They do different kinds of clothes. Neither one of them's name is Jake Joseph. So, they have to explain to the USPTO, we think somebody would be confused. Like, take Coca-Cola. Maybe somebody else came up with RC Cola. And so, Coca-Cola is going to, sue RC Cola and say, well, the word cola is in their name. So maybe they think that I'm related to Coca-Cola. And so that's the kind of argument they make. So we had to go through, it was a combination of negotiations to get one of them to withdraw their opposition, and it was actually a whole bunch of maneuvering to get the other one's opposition to fail, but we ended up getting it registered. But again, you just really never know what's going to happen. It doesn't require the trademarks to be identical. So.
This is what you probably have to look over your trademark.
Yeah, so you just never know. But as my esteemed colleague said, these are things that are going to affect you every day. Because if you come up with a company and you name it, your name is John Smith. I'm going to name my company John Smith. Well, you might find out that even though you never tried to register a trademark and you don't really care, you just want to name it, after your name, there might be a whole bunch of companies out there that really don't want you to do that. And so it's just stuff you have to be prepared for.
So keep in mind, if you're going to register a trademark, the process kind of starts with figuring out what you can register to begin with. What's the subject matter that I can register? So going back, it was a word, phrase, symbol, or combination thereof. So for example, look at Nike. Well, they've got the word Nike that identifies the company and their brand. They've got the swoosh, that's the symbol. Then they've got phrases like, just do it, or no games, just sports. So they've registered those as marks that identify Nike goods. So could they register something like Nike fast running shoes? Do you think they could register that? Can they stop other shoe companies from using the phrase fast running? Yes or no? Any ideas?
So you can answer. Yes.
How many think they could stop other shoe companies from using the words fast running together with their shoes? Yeah. Okay. So you think they could register that? How many think they couldn't register that? There's something in the law that stops it. Yeah, okay. A lot of you have got the idea. So the law provides a set of standards that says what kind of marks you can register and what you can't. So you cannot register, there's a very strong prohibition to registering a mark that's descriptive. So if you can register something that's descriptive, like the words fast running or the word computer or just other generic kinds of words, then you shouldn't be able to do that. You could stop a lot of competition and all kinds of things that your competitors would want to use in their advertising that they honestly should be able to use. So the law says if something is a generic word like computer or fast, or a descriptive word is the next one, then you have to show, you have to establish to register that. You have to show that you have an established meaning that word is associated with you. So with generic, say, if they wanted to register a computer, you're just never going to get a registration to the generic word computer. If you wanted to register fastest computer, well, that would be really tough. That's descriptive. The word fastest is very descriptive of the operation of a computer. So to do that, you would have to, through the law, you would have to show that your computers, through all of your sales and all of your advertising, that term, fastest computers, is going to be associated with your business. And that's called secondary meaning. And if you can prove that, then you can get a registration, but it's really, really tough. So you never want to start out your process trying to register something that's generic or descriptive. It's going to be very tough. It's going to be expensive. And to prove the things you need to prove, you've got to do a lot of legal work, and you've got to survey a lot of consumers and prove that those words you're trying to register have a meaning that's associated with your product only. So that is how the law kind of keeps trademarks fair. They keep people from registering words or phrases or even symbols as well that are generic or descriptive that would unfairly prevent the rest of businesses from using those words, which ought to be open. The word computer, the word shoe, the word fast, that ought to be open to anyone to use to describe their products if they want to.
You have a question?
Right, sure, yeah.
So that's sort of why Boston Strong, like I think 8 or 9 groups of people are coming in and trying to get Boston Strong as a trademark. Is that like because it's what every for the event and just like everyone's aware of it? That's sort of why
More so is one's a geographic indicator and one's a really descriptive.
Yeah, sure. Yeah. So there's two. That's partly why. So the answer was one of it's a geographical indicator, which that goes along in the law with descriptive, right? So you're not allowed to register just by itself geographical indicators. So there's a lot of law about when you can use the name of the city or the county or the state or whatever in your phrase, and usually you're just not allowed to do it. So then strong is the other. But that is a phrase. You might could get there in some ways, but you would have to show secondary meaning. What do you think?
Yeah, so, and that's a good point too, but, so here's a good example for Boston Strong. So, and this applies to, or at least probably is going to interest quite a few of you looking at the tops of your computers. Apple. Apple is a descriptive term when you're talking about a fruit. Apple is not a descriptive term when you're talking about a computer, which is why Apple was able to register the name Apple for all the computers that you guys have. And they've given it a special meaning as related to a computer. So Boston Strong, the word strong by itself really doesn't mean anything, but now that everybody is using it, with respect to what happened, during the marathon, then, and it's going to depend upon, who used it first and when they used it in commerce and, basically who won the gold rush to the USPTO, but they will probably be able to claim that Boston Strong, that phrase, even though Boston by itself doesn't mean anything, strong by itself doesn't mean anything, the combination probably does. So it's the same way with Apple.
Even then on Apple, though, when they started the computer company, they ran into a little bit of a problem because, of course, there was a record label out there called Apple Records. And they essentially said, well, wait a minute, we've already used this term for products. And said, well, but you're in music, you're in computers. No one would ever use computers for music, And so they agreed back then that, okay, we'll coexist. You say we're not going to do anything on music, and we're just going to be computers. Now, of course, a few years later, they, had their, coming up with the iPod and everything else, and they've had to since renegotiate their dealings because now they are into the music field. But again, no, it is money. Lots and lots of money. Anyway, you can go on this, but you got a question?
Where's the boundary then between a word that describes something and a word that's trademarkable? Because candy, for example, is out there.
Candy Crush Saga? Yeah. It depends.
Yeah. There is no boundary. There is not. It's really going to be what you can prove. You know, they are very, you know, that company is very, very protective over the whole name and every part of it. I mean, they're suing on Saga, you know, they're suing on Candy. You know, and so they will be successful if they're able to prove that not only that entire phrase, but every part of it has got secondary meaning specific to their company and what they do.
Eject one little side point on this. Another aspect on trademark law is the idea that you have to police your trademarks. Now, you know, everyone can, you know, you can make jokes about the RIA or ASCAP or, you know, various people that go out and, you know, sue people for downloading whatever else. But in the trademark arena, it's one where if you don't aggressively police your mark, then it can what's known as go generic. Aspirin was a trade name at one time, but because everyone started using the word aspirin to describe their salicylic acid compounds, they lost the protection. And you know, there are lots of other ones. Xerox probably all but went generic, but they were very aggressive about doing this. So that's something else that you focus on, you know, where are the lines? If those words have been used, even if they might, you can do it academically, they might be protected. But if they're in common use, especially if, you know, people have used them after you've been, quote unquote, staking your claim to them, then they can go generic, and then you lose the protection even if there was some to begin with. And again, important concept. Okay, we saw some questions here. Hands. Yeah.
So, let's say it was like a computer company, and they use, like, you know, like, unless it was like Japanese, and then they use the word apps, but it's Japanese. Are they allowed to do that? I mean, like, they would associate it with, people would associate it with that Japanese word, but it actually means apple.
That's an argument you're going to make in court. You know, it depends. You know, if, you know, it all relies on this idea of confusing the consumer. If the consumer would say, okay, well, there's this Apple computer Japanese company, there's this Apple computer US company, there's no chance anybody can confuse the two companies, which of course I can already tell you that that would work. But let's just say that, you know, that was a good argument, then you'd be allowed to. But if, you know, that argument didn't hold weight, then you wouldn't be. So it really just depends.
There's case law on translations of foreign words, and usually you're not allowed to register that. So usually Apple would win in that case. But he's right. There's no statute about that. It comes down to the history of case law in the U.S. and how they interpret, you know, the standards of law. The actual statutes themselves are really short that establish the law that governs what you can trademark and what you can't. So we talked about you shouldn't usually be able to trademark something generic at all. If it's descriptive, well then you need to show some secondary meaning and it'll be hard and expensive, but yeah, you might get that mark trademarked, registered. The next one is suggestive. Now we're getting the marks. If you can't do generic or descriptive, well you can do a suggestive mark. If it suggests something about that product, well, that you're way more likely to get it registered. So suggestive and fanciful are the other end of the spectrum from generic and descriptive. So it goes generic, descriptive, suggestive, and fanciful. Suggestive and fanciful are the kind of words that you want to come up with, and marks like Apple for computer. That's entirely fanciful. There's no relationship between apples and computers. Suggestive would be like, I've got a client called, they do tools that do database tools, and their name is Intoolect. So it's not intellect and it's not tools, it's the words put together. So that's suggestive, but it's not directly any descriptive words of their product. So that's where you want to, the best marks that you want to create to get them registered for your business are suggestive or fanciful types of marks. So a question over here?
In your opinion, do you think that trademarks becoming generic helps a company more or hurts it more, like Kleenex or Pampers becoming more generic?
Oh yeah, very good question. Personally, I think in most cases it hurts the company. I think Kleenex and Pampers had a lot of brand value built up in that, popsicles. They had lots of value built up in their brand that gave them a lot of power in the market. And so for those terms to become generic, I think they lost a lot of value. Generic terms like if Google becomes generic, and it largely has nowadays, but they're still enforcing it in some areas. I think it kind of helps them a little. I'd be interested to hear from Google's counsel about what their thoughts are, but I think in some cases it can help. I think most cases you want to enforce your mark and keep it from becoming generic, because as a rule of thumb, it's going to hurt you. It's going to hurt the value of your brand.
I would agree with that. I would say the general rule of thumb is having your mark go generic is bad. The perhaps exception to that is one where it just becomes cultural, like Google. But that's the rare case. Is a general rule of thumb in terms of what you want to be doing as far as your business plan. Having a business plan that I've got to start up and we're going to have our mark go generic to increase. No, because then anyone can rip you off. Way back.
Yeah. So in relation to Mr. Renfro's story about the Joseph's Clothing Company, how costly and or damaging is it for smaller Kickstarters like that to police their trademark and enforce them?
Yeah, so, well, and he was fortunate because I did this for free.
That's not
So, the lead counsel at one of these multinational conglomerates was a New York, pardon my French, asshole attorney, and he had no qualms telling me that he had a $10 million budget just to enforce trademarks. And of course, my friend had a $0 budget, maybe a negative dollar budget. My experience has been trademarks are super cheap until they're really, really expensive. And so for him to file it really easily, to get it registered, it's really easy. Most of the expense either happens during the potential opposition phase, like I was talking about, where you're having to fight all these other companies and you have to go prove all these things that my colleague was talking about to show that you deserve this mark. The policing, I would say if we were talking about this 15, 20 years ago, I would say it's very expensive because you actually have to go out and look for this stuff. But nowadays, you can Google it all day long, and what I've done for most of my clients is something free, which you set up a Google alert and you type in Austin Renfro and you save it. And then anytime that pops up, then you know that somebody's using it out there somewhere. And there's very little in the tangible world that's not, replicated somewhere online, and so you'll find out about it. So you will have some additional expense to enforce it if you have to actually drag them into court. But generally, if they're using your mark, if they're using your exact mark, and if they're in a similar line of business, it's going to be a pretty cut and dry case. If they're using your exact mark and they're in a little bit different line of business, it's going to be harder for you. But the law is with you per se. You've got you've got the rights there. You've got them set down. So they're prejudiced against the other party. If they're using a mark that's not the exact same mark, like what these companies were trying to say, or if it's not the exact same mark and it's a totally different line of business, it's going to be very, very hard for you to prove that. And so, what my colleagues were talking about before with having to police the mark, it's just how far do you want to go? And it's really a judgment call that you have to make as counsel to say, well, I'm going to let Jake Joseph go because my company's name is John Joseph. And so I'm okay with that. I don't think it's going to be a big deal, either from a business perspective or losing my trademark perspective. But if you're not careful and you're like, oh, I'm going to let Jake Joseph go and I'm John Joseph, and then 5 years down the road, John Joseph becomes, or Jake Joseph becomes some huge company, then you might find yourself at the other end of this, which is like, oh God, they've got a registration and so do I. And so, now other people might come out with, Jacqueline Joseph and Johnny Joseph and like all these other different names that are similar to mine. And so I've lost that protection.
And again, it's easy to focus on the hard calls about what's the line. A lot of just the nuts and bolts of the policing practice is dealing with the actual rip-off artists. They are not only using your trademark. They are aggressively trying to confuse the consumer. You've come out with a good product, you've got your mark, and suddenly up pops somebody else with the same line of product with your mark. if they're actually, affirmatively counterfeiting your stuff, okay? And believe me, it's a huge problem. And again, if you're starting up a business, you're trying to establish brand identity, particularly on high margin items, and it can be cheaply, once you develop the market and you can, make it for less and sell it for high, people are gonna come in and wanna steal from you. And again, one of the ways that you stop that, one of the tools that you've got, is the aggressive use of enforcement of your trademark, because you can, either get an injunction, shut them down, sue for lots of damages, or more commonly, where you're talking about, pirated or counterfeit copies coming in from overseas, you can actually go through customs and get it stopped at the border, and that's the big hammer. So again, we can focus on, how close are the lines, but just remember, a lot of the stuff you're really dealing with isn't someone trying to be clever or, someone coincidentally has something that's similar. You're talking about people who are aggressively stealing from you. And what do you do to stop it, and what do you do to make sure your protections are, highly polished and razor sharp and ready to cut somebody if necessary?
I think generally, good businesses, they don't want to be close to others' marks. They want to have their own clear brand that distinguishes them in the market. So I think he's right. A lot of the problem that you have, the majority will be people who are literally ripping you off. So just remember that the government doesn't really help you much with this. It's not like there's a trademark police or a copyright or patent police that will go out and stop others from copying your stuff. Right, you have to go find the infringers, and you have to send them letters, and then you have to file lawsuits against them. So the only thing the government really does, and there's very few firms that do this, is if you're seizing counterfeit goods, they will send federal marshals out with you. And you go in the facility, and you point out the goods, and the federal marshal picks it up and takes it away. So we've actually done that, where we went and seized goods, and in China we seized the goods, and then the Chinese government bulldozed the factory for us. So that's pretty rare. I think they were just doing it as an exhibit to kind of, give face to the idea that they're going to enforce trademarks, right?
And the fact that the partner in China just happened to be the Red Army.
Right, exactly. That was the government entity. The rest of the infringers in China, they don't really seem to care about it. So we had some questions over here. Okay, where? Sure, yeah. Almost always the agreements between those two, it goes to the company. Because the designer's not going to be able to raise money and get investment if the company doesn't know that it's protected and that they're going to own it. So they require him to assign it all to them. Now, in the rare case, when you have a really famous designer whose name really means a lot, then he can retain some of those rights. But usually it would be the right to that particular line of clothing and nothing else. So the basic answer is usually it's the company. The law says, though, that whoever creates the mark and uses it in commerce is the original owner. So if the designer started it, kind of bootstrapping it out of his garage and making these clothes and selling them, then he owns it until he goes and sells that to someone else.
So in the technological world we live in, how does this translate to the website? For instance, if you go to eSign.com, it actually takes you to your company's website. There's a giant banner on it that says, please help us retain this name.
We'll actually cover that a lot more. Domain names are another form of IP recognition. There's new types of IP where it's like that's moral rights, geographic indicator. Mr. Renfro's a big fan of.
The short answer there is the Nissan car company screwed up. They should have jumped on and got the domain name as soon as it was possible to get the domain name. So.
Yeah, but there is a process, and I've been through it many, many times, where you'll have someone who's an entrepreneur who'll say, I know this new company, Apple, that's about to come out, and they're really big, so I'm going to buy Apple.com, and there's actually a process that you can go through with ICANN, which is the domain registrar that has been in the news lately, and you can go through a process with them in order to get that back. Depending upon the situation, it can be really easy, it could be really difficult to do, but generally we've been pretty successful with it. Sometimes it's not worth it. And they're not going to just give it over just because you're a bigger company. You're going to actually have to prove to them, this person bought this specifically to, yeah, exactly, hold you hostage and force you to pay them exorbitant sums of money. Like I'll get, it's funny, I don't know what happened in cyberspace in the last 2 years, but I've been getting tons of emails from people that have registered variations of my name at different companies. Like I've got a Renfro.uk, and I get an email from them every month, like saying, "Hey, do you want to buy this?" I'm like, "I don't want to buy that." But and so somebody's paid money to register that, and would love for me to pay them $20,000 to get it back, even though it costs them $10 to register it. So. Oh, I'm sorry. Yeah, okay. Well, that explains a lot. but there is a process to do it, but it has to be legitimate. You can't just try to steal something from somebody else.
We'll go from there.
Okay.
So let's get back to enforcement. So, we talked about what you can trademark, and then, how you get it is you apply to the federal government, and you apply to your state, and you register your mark. So then you need to police it or enforce it. So generally, I think there's a whole lot of law about that, but I think there's a few words that we can summarize it in that pretty much encapsulate the whole law, and that is the words likelihood of confusion. So generally, you're going to infringe a mark if you've got something that's the same or similar enough that there's a likelihood of confusion between the trademark products and your products. Right? And so it all boils down to that. When you first start a business and you register your mark, you may get a letter from someone who's got, that name trademarked in another industry, and they may try to scare you away. So you should be scared if their industry is close to yours. If they're far enough away that there's absolutely no likelihood of confusion, then you're pretty sure that they're not going to win that case. And so you can be comfortable to move forward. So it's the same standard that they use in court. It's the same as they use to register it too. The examiner and the government who's going to examine your mark when you apply for your registration is going to be asking, is there a likelihood of confusion between this mark and the other mark? And then the judge who is in the lawsuit and gets sued on a trademark, they will be asking the same question. Is there a likelihood of confusion? And then all the rest of the law, the evidence presented in court, goes to really that issue. There's a few other minor issues, but that's a good thing to know. Just write it down and remember it. Trademark infringement is all based upon likelihood of confusion.
Let me talk a little bit briefly on remedies, and that is, if you caught someone infringing your trademark, let's say you've got your business and you caught someone who is the actual, person who's ripping you off and putting in counterfeit goods. Okay, what do you get? All right, you've got yourself a lawyer, you go down, the judge or the jury finds that they have infringed. What does the law allow you to get? And again, I'm speaking mostly under federal law. You're going to have a little bit of difference going state to state, but pretty much this is the general rule. You're entitled to get, first of all, your actual damages. So to the extent that you can show that your profits or your market has been impacted by this, to the extent that you can quantify this, which usually is going to require some sort of expert proof, then you can recover that. In addition, in theory, you're also entitled to get the profits of the infringer. Now, that is what the statute says. The gloss that the courts have put on that is that, but it can't exceed a reasonable royalty. So you're pretty much kind of back down to your thing. But again, it's another mechanism on this. And we'll talk about profits in the copyright area where that gloss does not apply, and it gets real ugly real fast, but save that for a few minutes. You're also entitled to get, if you prove some important steps, the court can issue a permanent injunction, and they often do in trademark cases. But you do have to prove that you're suffering irreparable injury, which is something that can't be compensated by a monetary award, but again, judges are usually pretty good about doing that. You don't have, generally speaking, criminal penalties for trademark infringement. And I can think of some ways you might be able to slide it in, but generally speaking, the Department of Justice isn't going to throw people in jail for that, even if they could. But the main things that you're looking at, of course, you can get monetary damages, you can get an injunction to stop them from doing it. If you go through various administrative things, whether it's through the ITC or through customs, You can get the importation of infringing goods stopped at the border. And of course, something near and dear to my heart, you generally can also get your attorney's fees, which can be very important because, you know, good IP lawyers are not cheap. We're easy, but we're not cheap. Okay,
At least the litigators.
that's right.
Check the really good ones.
Okay, good.
So then, question?
I'm an engineering major and will have an entry-level position, and I'm concerned about like a potential supervisor, you know, taking credit for ideas that I might have and speak with him or her about. How would you suggest I like make sure that like I can prove that I came up with my ideas and
Yeah.
don't speak to them?
So that is going to depend entirely upon your contract. We'll get to this in a minute. I think we might actually switch up the order of patent and copyright so that I get to where I can. Oh, sorry, I don't. And we're going to save the best for last. So, but to answer your question in short, it's really going to depend upon your contract. What he was talking about before, to her question over there with trademarks and you know how that works with the designer, it's going to be true for you. And really, your concern as an engineer, I'm a double E myself, is going to be like, what is your contract language? And you will see probably the same paragraph, the same 2 paragraphs as everybody else in this room, no matter what kind of job they have, if they're working for a company that knows what they're doing, which is that you're going to sign over all of your copyright rights, all of your patent rights, all of your trademark rights, trade secret, everything else to the company. And so the trick is going to be, it's enforceable up to a point. And that point is that you are working, you know, you can see language that's crazy strict, but it's probably going to be, if you were working on something on company time, in the line of business that you're working on, like if you are doing software development, and you come up with an ice cream machine, they're probably not going to be able to claim the ice cream machine. You know, but if you're working on ice cream machines and you come up with a better ice cream machine, like they'll probably be able to claim that, and there's very little that you can do about it. You know, smart companies are not going to want to negotiate with you about that because that's where the big bucks are. So, and then I know that there's a lot of other questions. I'm going to try to hit geographic marks real quick, and then we'll see where we go.
Awesome.
Yeah.
We're just talking about what companies now do for your money.
Yeah.
If we were contractors running for most high-tech companies, it would be mighty clause as well. We would also, outside that time, or you would not have the right to do it outside that time. Whether that was enforceable depends on the jurisdiction.
Yeah, and
It really comes out of contract law, it's not like.
yeah, and I'll be honest, something that I didn't learn until I was an attorney, and I'd signed tons of contracts as a college kid. And, you really, and it depends on the size of the company. If you're working for like A&D, you're screwed. But if you're working for like a smaller company, don't just accept the language as it is, particularly if to you it looks a little restrictive. And get your company or whoever you're working for to explain that language to you as well. Because you might find that you can negotiate that, and you can say, hey, like, you know, maybe I'm not going to own this patent, but maybe I get a percentage of royalty, you know, on that. And so, you know, now it's not as bad as it was before. So, anyways.
You've got a specific side project.
that you work on, and a lot of engineers do this, just carve it out explicitly. Say, I have this project I work on, none of the inventions related to that will be assigned as part of this agreement. And you have the right to negotiate that up front.
Yeah, and also just be careful. Don't, if you got an idea, like for an ice cream machine, you're working at a software development firm, don't use their computers to work on it. Don't use your email address with them. Don't talk to anybody in the company about it. Don't do any of that. Make sure, yeah, but it's true. Like, you got to make sure you create a bright line between your job responsibilities and the stuff that you're doing. And they may still be able to reach in and grab it, you know, but the more you can put a barrier in between, the better.
Especially don't use their prototyping equipment.
Yeah. So if you can prepare yourself and just create as much of a bright line as possible, then that's the best thing to do. Yeah. So real quick, I'll go over geographic marks. I love this topic. We can try to get to your question in just a minute. But I'll go over it real fast. The reason why I like geographic marks is because you can go to the grocery store and see them. And even though you can, most of you probably don't even know what you've been looking at. So geographic marks, and this is a relatively recent thing in trademark law, a number of countries and regions said, you know what, we don't have a trademark on this thing, but people like this product that comes from our area. And that must have some sort of value, and so we need to do something to protect it. So, as you can probably imagine, this originated in Europe. And the reason why is because the Europeans have a lot of very specific regional goods that are known around the world. For instance, champagne from Champagne, France. Gruyere from Switzerland, from that area for, for the cheese. And so they're like, we see a lot of people who are knocking off Champagne. And maybe some of you guys are too young to remember when this transition happened, but they started enforcing that Champagne can only come from that region of France, which is why now a lot of Champagne-type wines that you see in the store are called sparkling wines. They used to all be called Champagne. It's because they started enforcing that, and because the U.S. joined a number of accords with other countries in order to protect that. And we've started, and it's been much slower than Europe and some other areas of the world, but we've started to develop our own geographic marks that we're very proud of. Yeah, exactly. I was going to say our bourbons and our whiskeys and things like that. Also, our Napa Valley wines, our Sonoma wines. And it's not always, but usually food related. But it's very interesting. So you'll see, and I always butcher this because my French is stupid old, but you'll see article d'origine contrôlée, which you'll see like an AOC, and you'll see that on a whole lot of French goods. You'll see that on all the champagnes, and it's this little old-looking sticker, and it's got AOC on it, with a little star next to it, and it'll actually tell you what region it's from in France that you're buying. So that's just kind of neat. That's just another type of protection. So real fast over geographic marks. Anything else? Okay.
Before we leave trademarks,
Yeah.
quick question.
You were mentioning how when you find somebody who's counterfeiting a good, take certain measures to stop them. What jurisdiction does your law have? So if let's say you're having this problem with somebody say in another country who's counterfeiting products, what do you do?
Okay. U.S. law, as a general rule, U.S. law is going to stop the border. Okay? So you can stop someone that, let's say, for example, you've got a widget, you've got a trademark on the widget, someone is buying it off in China and bring it into the U.S. and selling it. Can you sue them in the U.S. for selling that? Sure. Assuming you can get jurisdiction on them, if they're overseas and they don't have any operations here, they can kind of an empty suit. You can go after the people that sold it. You can block it from being imported into the U.S. It may be that if you have gotten your trademark also registered or protected in the country of origin, for example, in China, there are a number of ways to do it. This would be a long, involved conversation on how you would do it. But in theory, could you get your mark registered in China and therefore go after them in China? In theory, yes. Although trying to do any sort of litigation in China is a fool's errand, generally speaking. Now, this is really bleeding edge, stuff in the law right now. But there is a way where, for example, if you sue, let's say you could get, like, a real world example. Y'all familiar with the old NetNanny software that people would use to put on their computer so their kids couldn't serve porn or whatever. Their parents probably I'm dating myself. Anyway, there were any number of companies that had the NetNanny software algorithms out there. Well, when the PRC decided to put in the Great Firewall of China, they effectively installed what amounted to NetNanny software on every machine sold in the country. And the way they did it was they had it, put in firmware in each computer, as it was manufactured. Well, there's only one problem with that. They literally stole the code for a lot of us. And so you had the stolen code being put in firmware on all these machines that were being manufactured in the U.S. and then being exported to China. Well, when the software people found out about it, they sued not only the companies that were doing this, albeit unknowingly, they also sued the PRC, saying you're involved in piracy of our work. But in this one particular case, they sued in California, a federal court out there, but then they also brought pendant claims saying, while you're at it, Your Honor, they're also violating our rights under Chinese law. And while you're at it, while you're adjudicating this one, you can also adjudicate our rights under Chinese law. And the court upheld that and said, yeah, I can actually do that. Now that creates, like I said, this is really bleeding edge stuff, but that creates a way where in many cases, if you have extraterritorial infringement or infringing activities going on, you may be able to do it in one full swoop in a U.S. court. But that's going to take some fancy dancing. But general rule on this, just the thing you need to remember, whether it's U.S. copyright law, U.S. trademark law, U.S. patent law, U.S. trade secret law, it stops at the border. You can stop people from bringing it in. You can stop them from doing things within the borders. Once they step outside, you're on your own. You're going to have to deal with it under the law of wherever they are. Now, a lot of international treaties, in the copyright arena, you've got the Berne Convention, you've got PCT and various other things. There's a lot of things that you can do in order to help out. But generally speaking, you're going to have to go to the courts of the country where you are.
Can I interject my rules? Just with regards to that. Trademarks weird and exist at different level of laws. You have what was described earlier as common law, simply by using it. Only protected within the geographic area which is used. Then you have state registration, which means it's protected statewide. Then you have national registration, which can be U.S., China, Singapore, or whatever. For example, when I register something, I'll register in multiple countries. Then you have, as you mentioned, international protection, which is PCT, or Berne Treaty. So it all depends on which level you actually register for what protection, or whether you register at all. Just to add on to what you say. What's your question, number?
Did you ever, like, say, let's say you were Apple in the early days, you had the first day you email the iPhone, 2 weeks later you find out something, people are starting to knock it off in another country. Would that create a sort of barrier for you to go into that country and make that market as well, potentially? If you weren't able to get a great market on it in that country?
So it depends on how country's law. Because I can tell you just from personal experience that most U.S. companies just, they don't do try. They really don't. China is so, for many, many years, China didn't have any IP to protect. And it's only in recent years with industrialization that they are becoming more of an intellectual property-based society. And I know I'm not just ragging on China, this is true of a lot of other countries too, but yeah, and so they actually care about that now. But I mean, relatively speaking, you know, most people just give that up, particularly small companies. You would never have some tiny company saying, I've started in the U.S., I'm going to go off to China and try to enforce my trademarks. Plus, you got to remember too that you don't have a trademark until you actually use it in commerce. And so if you, I mean, technically you could register, you can say, I'm going to use this in commerce soon. You can't say, hey, I'm going to come up with a clothing line in 5 years. I'm going to go ahead and register that now so that it's available for me in 5 years. It doesn't happen like that. You actually have to use it. So, yeah.
The reason for that is that's why you don't have people just going and saying, I'm going to register every, give me a dictionary here. I'm registering everything in here. You can't do that. You have to show that you're actually using it in commerce or in the U.S. intend to use something you go here to actually do it.
So, yeah, right here. EU law has made the playing field in Europe a lot easier for companies to enter. Is that the same case